That's literally what my coach used to say to me before races.
What do you say?
What, turn left?
Turn left, hurry back. Thanks, coach. Oh,
A good line.
yeah.
All right, we are back live with Damian Leonard on H66. We just heard from JFO, just giving us the rundown again on the numbers, and again for the committee that obviously if the presentation they gave us a couple of weeks ago is still valid, that's what we can refer to. Damian has presented us with draft 1.1, so we've been working off the bill as introduced, and so we talked a little bit about this just as a format thing. Now you're seeing what a bill looks like when it's in draft form. It's like a little letter to the House of Representatives, to the House of Representatives, the committee, et cetera, et cetera. This is setting this up by, it will be amended, or amending the bill as introduced by striking out all after the enacting clause and inserting in lieu thereof the following. And so Damian, this looks like we had asked you to restack the bill so that the PFLA section, the unpaid leave section was first.
Mm-hmm. Yep. So once I'm in the Zoom room, I can share the bill and I will go through it. I'm going to actually be going through in Word. So you're going to see me typing notes and comments on the screen. I'll try not to be snarky.
About Word or about our suggestions?
My comments on the screen. No, I'm totally kidding.
It's like, unless you're, no, never mind. You don't ever criticize yourself. You should.
Moving on.
Yeah, moving on.
Are you getting a link from Ron?
Yeah, I'm in the waiting room. So,
Is Ashley still in the waiting room?
I still don't even have a link.
As soon as Ron makes me a co-host, I'll share my screen and then we can get started. But yeah, so you'll see me making edits as we go along, just because I've not had time to print out a paper copy for myself to write on. So we're gonna just be going through this live. So, okay, there we go.
And so we're gonna look at this like you have highlighted all of the changes, suggested changes.
Yeah, so if I've made a change or there's a point that you wanted highlighted for committee discussion, I've highlighted it in yellow. If you see any other colors, that's highlighting that I somehow missed, and we'll discuss it when we get there. So,
And so
use other colors, but never for the actual changes. So,
And so committee, as we go through this, I just was a few pages ahead and I see where Damian had put in alternative 1 and alternative 2. Those tend to be lesser. They're not necessarily only technical changes. They might be substantive changes, but let's give thumbs up and thumbs down on the changes as we go along. If there turns out that there's a thumbs up, thumbs down substantive change that we need to have a longer policy conversation, again, I'll try to gauge whether or not we're going to get into a rabbit hole and we need to have a separate time to like really block out time so that we can think only about one particular thing. But let's just get through this. I think seeing what the changes are, and then again, we'll check off the ones that we're good with, and we'll come back to the ones either later this morning or this afternoon on the ones that we have to review deeper. There's definitely some policy choices that we have to make that we have to address. But things like on the bottom of page 2 where we added recovery from childbirth or miscarriage, to me we can have a quick conversation, but that seems to me to be a thumbs up or thumbs down on us as an example. But Damien, if you could just lead us through re-explain the changes that you're making, the alternatives that you're offering us. Let's just motor through.
Okay, so, first highlight, just because I've moved, existing job protected leave up to sections 1 and 2 like requested. Moving on to page 2. At the bottom of page 2, line 21, we've added recovery from childbirth or miscarriage. So I realized as I was drafting this too, that we didn't spell out recovery from childbirth. Just bonding or pregnancy, birth, and bonding, not actual recovery. So I thought that was important to clarify.
Does that work for folks?
Yes.
Okay, check.
Great. I'm going to unhighlight it since we've agreed on it. So E is the birth of the employee's child and to care for or bond with the qualified individuals. Whoop. That should be employee's child within 1 year after the child's birth.
As opposed to qualified individual.
Or, yeah, it could actually just be with the child. Just going to delete qualified individual.
And does
We
it
understand that it's the
type of
employee's child.
What's that?
We understand that it's the employee's child.
What to be, what does 1 year have to be hyphenated?
It does.
Okay.
So that is actually, whoa, wait a second.
No, it doesn't.
It doesn't. No, you're right. Sorry.
That's what we're doing, so.
This is what happens when you, I've already changed the timestamp, so you can't see when I was drafting this.
Please don't apologize for especially stuff like typographic.
Yeah, like we mentioned yesterday, this is unedited, so if you see something, say something.
Representative Burrows.
I don't know when to ask about this, and it may be a policy question that we have to have a further discussion on, but I noticed throughout the draft that the possibility of including rehabilitation from a serious injury or illness hasn't been included, only in the one spot that.
So what I did is I've given you the 3 alternatives. When we pick one, I'll make changes throughout the rest.
Okay.
So yeah, that was a time saving thing, so that I didn't have to add 3 alternatives at every point.
Okay. Thank you
so-
for clarifying.
Yeah, no, thank you for asking that. And I just, let's see. So, while we are on that topic, just want to go back to, thanks, Ron. Just want to touch base really quickly because we're going to get to that question in just a second. So I'm just going to pull up those regulations just so I've got them handy for our discussion. Okay. Yeah, okay. Okay, so we've added and to care for or bond with a child within 1 year after either birth or placement here. Is that okay language?
Yes.
Okay.
That's, yes, questions?
I'm sorry, I don't know why this just came to me. 1 year after placement, for foster care, there are times in foster care where you might have somebody with you for several years and then in year 3 something changes. Would they be ineligible to use this type of leave?
So
I'm thinking like maybe a reunification plan might change, the parent is unable to reunify.
This is a bond, this is for,
Yeah.
this is to say,
Okay,
this is for bonding.
okay,
right. So you would be eligible throughout that time to use it if there was like a serious health condition.
okay,
So if the child in foster care gets
Okay.
ill or needs care, that's covered under the serious health condition provision. This is just for the initial sort of developing a bond with the child after they've been placed.
Okay.
So that was a good question.
That's F, right?
That's F.
Okay, committee, are we fine with F?
Yes.
Yes.
Okay,
Line 19. And I'm sorry. E and F, the reason we went to the 1 year thing was actually that was sparked by the conversation about bereavement leave as well. That bereavement leave, we were giving a kind of a 1 year out qualification and I think that was implied in this language earlier, but
current law provides 1 year for bonding leave. So within the first year, you can take bonding leave. And so that is to make clear too, that we're also not curtailing current law or leaving it completely open-ended.
all right, so line 19.
Yeah, line 19, the question here was whether to add, so it says a person who stood in loco parentis when the employee or employee's spouse or partner was under 18 years of age. There's a question of whether to add in a person who stands in loco parentis for the employee. And above, we have a parent of the employee or the employee's spouse or civil union or domestic partner, regardless of whether the relationship is biological, foster, adoptive, or step. We also have a legal guardian. What we don't have is someone who stands in loco parentis currently. So that was just I can't remember when this came up, but that was basically the question, is it's only looking back for in loco parentis, which may be what you want. I think the hypothetical here is basically if you have a 17-year-old who's still got this in loco parentis relationship, or 18-year-old, that they would potentially be able to take leave under this for someone who's standing in place of a parent for them, even if they don't have that official legal relationship. So it could be everything from adoption not having gone through, parent is incapacitated and they haven't gone to the family court to get a legal guardianship, that sort of thing. So, and in some cases, you may have one biological parent, the other parent is not a biological parent and they've just never done the adoption paperwork, but they've been standing in place of a parent for years. So that's what this is aiming to, or what that would cover. And the question is whether you want to include that.
There are a number of scenarios where it could apply. There's no detriment to adding it, right? Is there any drawback to?
I mean, I think the question is just whether the coverage is broader than you intend if you add it. So I don't know that I can see specific drawbacks. It would potentially create an additional, pressure on the fund. There might be a little bit of additional uptake. I can't project how much that would be. And I'm not sure if that's something we can model, what this one language change would do. So it may put a little additional pressure on the funds. But you do have to show that the person has day-to-day responsibility to care for and financially provide for, to show that it's in loco parentis relationship.
Okay, committee, what's your pleasure?
Sounds good to me.
I'm not yet.
Okay,
Yeah, I'm okay with that.
I'm just gonna make a note to add this in because it's gonna take a little bit of additional work. next change, page 4. This one is a little bit more distant. Here, on line 6 and 7, this is grandparent who stood in loco parentis for the, it would essentially be for the employee or employee's partner when they were a child. So it is a more, or I'm sorry, the parent of the employer or the employee's partner. So this is like if your parent was raised by another family member who didn't have an official legal relationship with them. For example, your granduncle or something like that, if I'm using the right terminology. So yeah, this is a little bit more distant than that question of someone who's currently standing in loco parentis for a high school or college student.
We have,
Representative Parsons. Yep, Representative Parsons.
Yeah, the other one seemed pretty logical to me. This one, it's a bit of a stretch.
Would this be covered by the change on page 3? A person who stood in loco parentis?
So no, so the difference is stood in loco parentis for the employee versus grandparent level of the employee. So an employee can take time to care for their grandparent. This is a situation where your parent was cared for by someone who stood in place of a parent.
Oh, okay.
Yeah.
It's a little distant.
Yeah.
So pass on this.
Okay,
Yep.
so. Okay,
Now, this is adding a whole new definition to a section that I was having trouble with because there wasn't a whole definition.
yeah, so this would say, this would extend coverage to an individual with whom the employee has a significant personal bond that is or is like a family relationship, regardless of biological or legal relationship, under the totality of the circumstances. So we're looking holistically. And that includes evidence of shared financial responsibilities, such as a shared lease, common ownership of property, joint liability for bills, beneficiary designations, evidence of responsibility for each other's personal well-being, including emergency contact designations or an advance directive, as that term is defined by Vermont law. Evidence showing an expectation of care created by the relationship.
Time out. An advance directive, in this case, if I was filing an advance directive, you were my neighbor, you were my good friend, you were my whatever, and I asked you to be the person who makes the decision that the advance directive is addressing.
Yes. So this is giving someone a healthcare power of attorney or authority under a healthcare directive to make decisions if you are incapacitated. So this is not a financial power of attorney. This is the one we're referencing is the one where if you're incapacitated at the hospital and they have an advance directive on file, they would call up the person named on the advance directive, assuming the advance directive, didn't have like a very explicit do not resuscitate or something like that. They would call up the person on the advance directive to say, here's the situation. We need you to come in and make the decision as to how treatment is going to proceed at this point.
Which is done, I can't put you on my advance directive without your permission. You have to sign that advance direction, so it's directive. So it's not like it's out of the blue. It's a serious conversation. For me to come forward and say, would you be the one who could determine whether I live or die, knowing my wishes?
Yeah, it's something that involves a conversation between the two parties, an agreement between the two parties. It's not like a bequest and a will left by someone that you're distantly related to or something like that, who just decided to leave the money to you because you were their closest living relative or because of whatever reason, this is a document that you've got executed, both parties are signing, and it's a serious document because it literally dictates what happens if you're incapacitated with respect to your healthcare and who's going to assist the medical providers with making those calls as to how to proceed.
Representative Burrows and then James.
Thank you. Is there a difference in the eyes of the law between the person named in an advance directive and a medical power of attorney?
So for purposes of Vermont law, our definition of advance directive includes medical powers of attorney. So this would be including them both here. So whether you fill out the form or you have a document creating a power of attorney, this includes them both.
So just so I can be clear in my understanding, I have medical power of attorney for my mother, but I am not named in her advance directive because she wanted to invite a neutral party to carry out those wishes.
So go right just to the language here. I just want to make sure I pull up the right section. So I think that it's possible to have multiple documents dictating how things go. So what it's defined as is a written record executed pursuant to Section 9703 of this title, which sets out all the regulations on that, which may include the appointment of an agent, identification of a preferred primary care clinician, instructions on healthcare desires or treatment goals, anatomical gift, disposition of remains, and funeral goods and services. The term includes documents designated under prior law as durable power of attorney for healthcare or a terminal care document. So, and then if we look at the advance directive statute itself, an adult may appoint one or more agents and alternate agents to whom authority to make healthcare decisions is delegated and specify the scope of the authority. So you can say, if the situation is X, I want my child to make the decision. But if the situation is Y,
Right.
because of the nature of that decision, I would prefer to have a neutral third party make the decision.
Right.
So I'm not burdening my child with that decision or whatever the reason is. So
And that person, under this definition, would be allowed to take leave.
So you have to look at the totality of the circumstances. This isn't a checklist, check one and you're in. This is let's look at the totality of the circumstances, and that's what makes something like this difficult. Is totality of the circumstances is it's a bigger question, and the department's going to have to make a judgment call based on the evidence. Chances are, if you are, for example, if you designate, I'm not sure who the neutral third party would be, maybe an attorney or something like that, or a chaplain, who you know, but who's not going to be emotionally invested in the decision at that time. There wouldn't be the additional evidence showing that this family-like relationship exists. But that would be a judgment call the department would have to make when they're looking at the totality of the circumstances. They would also look at, for example, is there some shared financial responsibility, or, for example, with a child or a trusted individual, you might have them get notice of unusual transactions.
Sure.
Or that you've stopped making your mortgage payments, something like that, where they're helping out an elderly neighbor by ensuring that they're staying on top of their bills and that they're not getting,
But I think
Taken advantage of.
Checklist, not just one thing.
yeah.
Okay, are you all set?
No, I was just wondering if, so if you are the designated, I'm sorry, if you are the designated person with the, what do you call it?
Power of attorney.
Not power of attorney, the,
Direct,
advanced
Yeah.
directives. And in the scenario that we just described, it doesn't really have to do with a bond.
Right. So that's why, again, they have to look at all the circumstances surrounding it, not just one thing in isolation. So you would be looking at evidence of responsibility for the other's well-being, evidence of shared financial responsibility, evidence of an expectation of care between the two.
I got you.
Yeah.
Okay.
So, and then number 5 is a catch-all, including other significant evidence of, or other similar evidence demonstrating a significant personal bond. I went with what was in Colorado's regulations on this and then added this catch-all because I don't know what that other evidence would be off the top of my head. This list could be made longer, it could be made shorter, or if you're uncomfortable with it.
Representative James.
Yeah, I'm sorry, I need to step out. I just have 2 quick comments. I'd be comfortable seeing this category drop,
Okay.
knowing that our policy is iterative and that we could always come back and add it later once the program is up and running. I think it's vague, and to me, it's overly expansive. So I would be comfortable with dropping this section. And I'm sorry that I have to go, but on page 5, if somebody could please ask for me whether that might be an appropriate place to add in substance misuse treatment.
Okay.
Thanks.
Thank you. Representative Krasno?
Oh, well, so I learned from the conversation that it is not a checklist. It is not one, or it can be multiple things, not just one. So my concern about one of them was just, joint liability for bills could be like someone's roommate or, it's very,
If it was a checklist.
right. So my
Yeah.
question was answered that it's not a checklist, and so I'm good.
Yeah.
Thank you.
All right, yes.
I think I'm in line with what Representative James said. I've just always been troubled by the like a family relationship, and it seems even the list of items doesn't really even clarify it for me. It just keeps raising additional scenarios. And while I appreciate the intent, I think I'm also inclined to let that one go.
Representative Lamont.
I just want to speak in favor of keeping this in, because as someone who is in Vermont and doesn't have any familial ties, this is important and I know many other people in the community, like there's someone who's in the hospital right now who's alone and dying by cancer and from cancer and doesn't have any familial persons or people to take care of to be there with them or care for them. So I'm thinking of all the folks who don't have families and people who do have chosen families. And it would be important for them, especially my children, in the event that something happened to me, that someone would be able to care for them so that they would not become a ward of the state. So I would in favor for someone being able to care for people who are extended.
So let's keep it right now. We'll return, just mark this as a return, Damien, just
Okay.
for us to come back to. And as Representative James said, there's always room for, things that change as time moves on. So we'll come back to this. And Damien, I'm sorry, you're working off of a slightly different draft than what we have, so I'm gonna stop saying things like line 7 on page. I mean, for us, it would
Yes.
be, you're saying next change, and I'm saying top of page 5, line 2.
Yeah.
So,
On line 3 of my document, what we've done is taken out that lengthy, grammatically incorrect in loco parentis definition and just saying in loco parentis means a relationship in which an individual has day-to-day responsibilities to care for and financially support a child, which is the core of it. Good? Okay. Actually going to start turning these green because I realize our editors are going to want to know where I made changes. So bear with me here.
the next change is the healthcare provider. We've had this conversation that.
Yeah, so serious illness or injury. This one here, I was actually just looking again at those federal regulations as we talk. So it defines healthcare provider as a doctor of medicine or osteopathy authorized to practice medicine or surgery by the state in which the doctor practices or any other person determined by the secretary to be capable of providing healthcare services. And then serious health condition is defined as illness, injury, impairment, or physical or mental condition that involves inpatient care in a hospital or hospice, or residential medical care facility, or continuing treatment by a healthcare provider. And the regulations provide that the term treatment includes examinations to determine if a serious health condition exists and evaluations of the condition. It does not include routine physicals, eye exams, or dental exams. A regimen of continuing treatment includes a course of prescription medication, therapy requiring special equipment to resolve or alleviate the health condition, which includes something like supplementary oxygen. Over-the-counter medications are not included. Cosmetic treatments are not included. I do have concerns on reading this again. While I know from having provided legal counsel internally on FMLA requests for the better part of a decade now that, and from having studied this, is that things like substance abuse disorder treatments and rehabilitation from a serious injury are covered. I'm concerned that even this regulatory language is pretty opaque on that. Mm-hmm. So I am not going to tell you what language to adopt, but I think if you want to spell it out, you may want to shift to the serious health condition language and then spell out additional things that you believe are not clearly covered in that language, such as therapy for a serious health condition, recovery, treatment for substance abuse disorder, etc. It is important to note that under federal law and state law, active substance abuse disorder is not considered a disability. So if you are coming to work intoxicated or under the influence, that is not a protected disability, but recovery from substance use disorder is a protected disability. So that's an important distinction when we're talking about this. If you're talking about providing an accommodation or providing leave, it's for the treatment of the disorder. It's not because someone is currently suffering from the disorder and unable to work because they're intoxicated.
So Representative Krasna.
Yeah, I think it is important to clarify. I think about, I have someone that I know right now who has to go to a facility to work on, getting off of, buprenorphine, and so they're gonna need time. But when I think about like a Valley Vista or a place like that, it's not in a hospital, and it's not necessarily residential medical care facility. So I think that some sort of substance use language should be added.
To your point, Damien, and to what would you need to present us is, would you need to, I mean, I know there's policy involved, but when you're, compared to the language that's here right now, starting on your line 10 through the end of the highlighted material, what are you suggesting?
So I would propose, I would propose basically a combination of our current language and the federal language with the language I've added on lines 11 and 12 here, rehabilitation from an accident, disease, injury, or physical or mental condition that satisfies A, B, or C. And then I would say including residential treatment for substance abuse disorder. And I would want to just double check that I'm using the most appropriate term for that currently.
Yeah, go ahead. I'm sorry, finish up.
But yeah, so I would recommend taking this language, if I can just show you guys here. And then putting that there and putting want to make clear that we're not taking, so forgive the lettering, but means an illness, injury, impairment, or physical or mental condition that poses an imminent danger of death, requires inpatient care in a hospital, hospice, or residential medical care facility, requires continuing treatment by a healthcare provider, which we'll have to define, and also includes rehabilitation from an accident, disease, injury, or physical or mental condition that satisfies the above, including residential treatment for substance abuse disorder.
It says D for residential. Is that just a typo? I just want to make sure I didn't miss something. Rehabilitation.
Yeah, his letter.
Yeah, my lettering is way off.
Okay, cool.
I just threw everything together.
Okay, just making sure there wasn't something I missed. Okay, thank you.
So going up to healthcare provider, I mean, we talked about this on occasion, and you read a definition of healthcare provider that sounded sufficient.
So I would change the federal definition slightly to say means a licensed healthcare provider or any other person determined by the U.S. Secretary of Labor to be capable of providing healthcare services pursuant to the FMLA, because that will bring in, if your goal is to bring in folks who, for example, may be Christian Scientists and use Christian Science healing, which is covered under FMLA, but under our current statute is not explicitly covered. That would explicitly bring that within to the extent that it's been okayed for purposes of the federal law. And so that'll prevent you from issues of having a statute that may be religiously discriminatory or something like that.
Representative Parsons.
Well, thanks. I don't know what the exact definition is, or if we have it in our books. For healthcare clinician, would that be too broad?
I think we usually say licensed healthcare provider because that'll cover nurses, advanced nurse practitioners, physicians assistants, osteopaths, naturopaths.
Okay, I think that does.
Um,
I don't-
yeah.
I just didn't know if there was one seemed to work better than the other, 'cause I don't.
Yeah, I think we usually go that way, I think, in the other statutes. And so I would just try to be consistent to avoid. The thing I always worry about is a court getting in here and saying, oh, they use different language. They must have had a reason for that. And then misconstruing our intent. But I will double check with our healthcare team just to make sure I use the most up-to-date.
So you can bring that back this afternoon or so, or tomorrow, wherever we end
Yeah.
up. That would be great to see.
Um,
So that takes us to section 2, which doesn't have a change until our page 7.
All right, let me catch up with you. Yep, so here we are on page 7, middle of the page. Just added a miscarriage to the list of unanticipated events that may require leave. So, any questions on that? Is that okay?
I think that's a good addition.
Great.
That's the only change in that section. So, before we get into safe leave to 472D, well, let's just, I'm not, there's not a lot of changes in here, right?
No, but there's some discussion points on phasing the law in, which I can draft for you for this afternoon if well, I don't have time before this afternoon, but maybe before. I could get some language drafted for you for after the floor.
Sure.
I
I just wanna take a break from safe leave. I wanna come
Okay.
back to safe leave because we have Ashlyn Doyle is here from the treasurer's office and I just wanna respect her time. And knowing that once we get into section 4, which is the leave insurance program, if I could just borrow her time for a few minutes, Damien, and come back to safe leave.
Sure.
Because I think I want to hear testimony from the treasurer's office about the proposed changes. I feel like if we wait until we get there in the text, it's going to be another 45 minutes and stuff.
Yep.
Thank you. Dr. Tufar.
I won't.
And before we have Ashlyn come in, does anybody need to take a break?
I'm gonna get something to drink.
Okay, let's take 5.